an invoice that is sent out. And so the question, I think, just relates to what happens when these things don't mesh, when they're not consistent. And I think that, and Wanda and I both will address that, but it is important, particularly if you're sending them, to try to make those documents consistent. But it will often be, and that's why I refer back to the credit agreement, that you could want to establish, maybe even in the credit agreement, that anything that varies from this will not be enforceable, that this would be without some kind of a written agreement that modifies the credit agreement. On the other hand, it could be very well that if you have received, say, something that has different terms and you accept it, and then you comply with it, then you may be determined by a court to have accepted that and modified your terms of your agreement. And that's what I would be concerned about if later on you receive something that is different from what you would have otherwise sent out. Wanda, what do you think on that?
I agree with everything you have said, Bill. Thank you. And, of course, for the creditors here, what we're talking about is the classic battle of the forms. If you don't have a credit agreement, which most of you look at as your credit application, you're going to have these purchase orders. Maybe you'll have a confirmation. Now you'll have the invoice. Two things. One thing that Bill said that I want to emphasize, I completely concur with him. Get it in that credit agreement or that credit application. Put all your terms and conditions there. Or what's happening today a lot is that trade credit grantors will reference their terms and conditions by a link, so that they'll say all terms and conditions as can be found on www. whatever your website may be. But that way it is understood that all your terms and conditions are in fact what is going to be applicable. And I recommend language that says something like this: you must agree to all of our terms and conditions. No other terms and conditions of sale or credit shall be enforceable unless agreed to in writing and signed by both parties. And that way, when you suddenly get that purchase order that's asking you for net 90-day terms instead of net 30-day terms, you have language that says that doesn't apply. Our credit application, our terms and conditions apply. And the most important thing to understand is that the credit application, the credit agreement is really very, very important. The purchase order is important. The confirmation is important, but the invoice, by the time the invoice goes out, your sale is completed. The goods are gone or the service is rendered, and now the invoice goes out. Don't rely on putting terms and conditions in your invoice that aren't on some first other document, because an invoice means the job is done, it's completed, and you can't start infusing terms and conditions into the invoice after the fact.
Anything else to add to that, Bill?
No, I agree 100%.
Okay, so let's move on to the next question we have. Piercing the corporate veil. For companies that have been purchased by a private equity firm, how does one assess the strength of the PE firm, since they never share financials? Is a cross-corporate guarantee required for the PE firm to honor the obligation of the company they own in the event the company files bankruptcy? Why don't you start us off, Wanda?
Thank you, Dave. When these new startup companies are created, it is very difficult to determine whether or not they do have assets. And when they take the position of, oh, trust me, but we're not going to share financials. Well, you know that certainly we lawyers never trust anybody, and nor should you credit professionals. You have to have some kind of financials. And what you're going to find in a lot of these new PE firms is they may have a large infusion of cash because that's what they're going to use with which to purchase a company, but they don't have any background financials. They're not going to show you a P&L. They're not going to show you really much of a balance sheet because all they've done is literally created a new entity for the strict purpose of purchasing another entity. And you're going to see this in or out of a Chapter 11 proceeding. And in the Chapter 11 proceeding, maybe there's some more comfort because the court is overseeing what's going on. But when you're dealing with customers and you're suddenly told, oh, well, we now are owned by, or we have just purchased such and such, very wary to be sure what's going on, which brings us to this real second question. Is a cross-corporate guarantee required in order to get this PE firm to honor the obligation of the company they own in the event a company files bankruptcy? When my clients are dealing with new entities, I want everybody to guarantee. I want cross-corporate guarantees. I want the guarantee from the existing. I want the guarantee from the new. But remember, again, the new company is probably nothing more than money. And will they have sufficient financial resources moving forward to have anything to solidify or to back up that cross-corporate guarantee? But the real idea of the cross-corporate guarantee is to make sure that both old and new remain liable for the indebtedness, because what you can sometimes find yourself in is a situation such as, I'm trying to pick on some names that are common names. Well, let's take, here's my IT person. My IT company is a company called ITS Computer Solutions. Well, imagine you're a trade creditor and you have sent goods to IT Computer Solutions, Inc., and you're waiting to get the bill paid. And all of a sudden, IT Computer Solutions doesn't pay you. And you're told, well, we were sold and we are now owned by Tech Support Managed Services Corp. Well, now you go to chase Tech Support Managed Services Corp for the money owed to you, and they say, oh, we're not the same company. And now you're forced to try to dig into, did they buy the stock or did they just buy the assets? And that's very important to you. When some entity is telling you that they are about to buy or that they have been bought, you want to know if it was a stock sale or an asset sale. Because if it was an asset sale to a third party, and if in fact the sale was not a fraudulent conveyance, but a legitimate sale for at least 75% of the value of the business, but all they bought were the assets, then that new entity does not owe the debt of the existing entity. So that again brings you back to, well, then get somebody to guarantee it, or you could be stuck going after IT, who no longer owns anything, who is virtually out of business, to Tech Support Managed Services, who says all we bought were the assets, not the stock of the corporation. So that's when you have to be very clear on who bought what, who owns what. And of course, you notice the title of the scream is Piercing the Corporate Veil. And can you get behind that to the bodies who really enacted this transaction and get them to pay your bill?
Yeah, sometimes when I was a credit manager, I used to get bulk sales certificates or notices. And I think that's part of that. So Bill, why don't you continue?
Yeah, I was just going to say that you got to understand that if there's a separate entity, whether it's a holding company or something that you're dealing with, your credit depends on multiple corporations. And the question about piercing the corporate veil, that is not a simple thing to accomplish. That requires going to court. That requires establishing some neglect of the corporate structure between the entities, the commingling of assets, all of that. Then they would ultimately, if you can prove all that, they will show a merger of those assets into one and say this is really just one entity that you're dealing with. And but if you're having to rely on that, it's just going to be in a very expensive and difficult road to go down. So it's very important that as a part of your credit agreement that you're obtaining, that you get a guarantee perhaps of the multiple entities that are involved. And of course, you do need to also check those corporate records. Verify that they exist, that they're in their true name. Sometimes you just see that trade names and not their entity name. And so much it depends on getting the correct name, both in, as we'll talk about in a minute, secured transactions, when you're recording and getting a lien on an asset, and also just making sure you've got the right entity. There's some other things you can check, maybe Dun & Bradstreet and other stuff that on the viability of things, or word of mouth. All of those are important in dealing with credit, but a guarantee is certainly important in establishing that liability. Don't rely just on piercing the corporate veil.
And Dave, you mentioned.
I've got a couple questions here.
Yeah, I see that, and I'm going to answer one of them. But you,
Okay.
Bill, you, Dave, mentioned receiving bulk sale notices when you were a credit manager. And for some that may not know what you mean by that, there was, and I repeat, there was a bulk sale statute under Uniform Commercial Code, Article 6. That has been abolished in almost every state. What we tend to look at now that have replaced the bulk transfer section is really the Fraudulent Conveyance Act, which has recently been changed to the Uniform Voidable Transactions Act. So in almost every state, you're looking at a UVTA when you're starting to look at, was the transfer in fact made for good and valuable consideration? And the concept of what you were having under bulk transfer under Article 6, or what happens under the Uniform Voidable Transaction Act, is that the assets are transferred for less than fair consideration at a time when the debtor is insolvent or becomes insolvent by transferring of those assets. And then to Bill's point, of course, yes, knowing who it is, and the question that is up there, would obtaining a customer officer certificate wherein an officer of the company assures to meet the financial obligations when due will help. Well, that's kind of a two-point question. One, a customer officer certificate, or perhaps a secretary certificate, validating who the officers actually are and what the company actually is, or as Bill said, go pull it out of the Secretary of State or get a copy of the certificate of incorporation, will then tell you that the entity is a real entity. But your second point really means, are you going to get a personal guarantee from the officer of the company to ensure that they'll meet the financial obligations when due? And if you can get it, and if it's worth the paper it's written on, and by that I mean if they have assets, sure. But if they are assetless, don't waste your paper.
Yeah, I was going to say the customer certificate, officer certificate is good in verifying certain things that may be important, like name and stuff, but it's not a guarantee. And if it's wrong, it's wrong. And it, there's, so it's, it may not be worth the paper it's written on.
Right, and all this comes up too in the situation with shell corporations and holding companies and those situations. Do you have anything to add regarding that?
None other than what we mentioned about the shell entity and piercing the corporate veil. It's not automatic.
Okay, and one final question we have from Lancy is, what do we do if the new owner will not provide documents to confirm the type of sale? This is an obstacle that we often face. So what's your recommendations?
Don't sell, except on cash in advance or COD. And I kid you not, if in fact they won't give you any information as to their financial wherewithals, and you can't verify their information, then don't put your company at risk. Simply tell them, then until I can find out that you are actually in good faith and you are actually existing and actually operating, we're going to sell to you in cash in advance or COD basis only. Would you agree, Bill?
Yes, I would.
I'd agree too. If they're not showing good intentions, you know, from that point. So let's move on to the next question. And so
Went too far.
no, we went too far. What happened? This is,
There you go. Yeah.
there it is. So we're taking a look at security interests. So why is security interest so important to a trade credit grantor? And what's the best way to execute on a UCC security when the customer goes delinquent? So how do we initiate it, and how do we make it pay for itself when
Yeah,
something bad happens?
this is something that does, you know, it's probably worthy of getting some legal counsel to help you with, because it is critical and the rules are kind of difficult. I'm teaching it at law school, and it's a very complicated area. But you know, for example, what assets are you trying to get a lien on? And how you perfect a lien may vary depending on the type of asset that you're looking. They have simplified things, which means that you can look up and get the charter information from the state where the corporation is chartered. And that's where you do your filing. Particularly if you're getting a lien on equipment and inventory and accounts, and that's the normal things that you get a lien on. For a while there, it used to be kind of dependent on where those assets were located, and that was difficult because they would move. And so they have simplified it by making it based on where they're located. But again, it's important to get the right name, so that because if you do a filing and you don't have the correct name, you do it based on, say, a trade name or something, you may, if someone does a search and they're using the you know, corporate name, and you filed under the trade name, then they don't show that there's a lien, and so they can rely on that to your detriment, that yours is materially difficult. So tangible goods such as equipment, inventory would be one issue that you would want to worry about. What it is that you're trying to get a lien on. If they're assets that are attaching to real estate, then you've got to worry about maybe doing something additional by recording in the where the real property records are, what we call fixture filings. And for example, if you've got shelving in a warehouse, that may become fixtures to that warehouse, and that requires a little bit different. So all of this is critical to understand what it is you want to lien on, and then how you go about doing it. You also need a security agreement, and that is a document that where the other side grants you a lien. And if you know, you can have that security interest, but then you got to take the next step and record the financial statement with the Secretary of State, or the records are the Uniform Commercial Code records, and then that perfects it, what we call perfection, and makes it effective against third parties, which is what you really got to have. If you have just a security interest with the customer, and that customer files bankruptcy, you have an unsecured loan that does not have priority over the bankruptcy trustee. If you've perfected it, then you've got priority, and that's where it's important that you accomplish that. You also want to refer to after acquired property in your description. You want to have a good description of it, and you can be rather general. You can talk about all equipment or something. If you specify just different types of equipment and they replace it, then you may have lost your lien because you just specified different types of equipment and not just equipment in general. So it's better really to be more general when you're dealing with what it is that you're doing. And so the security agreement is important. That again is something that is done at the beginning. And the one thing that I think the question, how do you do it when they are delinquent? The problem is when they're delinquent, it's probably too late. Who's going to sign the security interest when it's, they know that you're getting it to shore up your debt, and you're going to probably execute it. So you're not going to get they're not going to comply. And then furthermore, even if they did, what's likely to happen? They'll file bankruptcy, and you've been doing it just right at the end of the day. And there's a 90-day preference rule that we'll be talking about a little bit that also comes into play here. So you've got to do it at the beginning if there's any chance for you to get a lien on those assets, and it's important to be thinking about from the very beginning. Wanda, I don't know if you've got anything you want to add to that. Oh, one other thing I'll say, watch out for name changes. When we're talking about sale, mergers, all of that takes place, and you've got a UCC or that's been a security agreement you've signed with someone, and now they have a new name, your lien on any future assets is going to be at peril. You might be okay with assets that they already existed and you had a lien on, but anything new, you're going to have to file a new lien to get perfected on those assets.
And I'm going to pick right up from what Bill just said about the change of name, and you only have a limited period of time to actually change that filing. And I believe it's 4 months that you can go and change the filing. But a couple of things, there's actually a question up. What is the interpretation of UCCs in the credit decision process? I will tell you my experience with a lot of my creditors, a lot of my clients, is they put the granting of a security interest right into their credit application, right into their terms and conditions that says, by the extension of credit, I hereby grant to XYZ company the right to file a security interest financing statement against me. Number one, I don't like that. I don't like that one little paragraph blurb granting you a security interest. Theoretically, it works. But as Bill said, you then have to take the next step of filing the UCC in the proper place where it should be filed. And if you haven't filed it, and later on you get a delinquent creditor, it's kind of too late because they're probably going to file bankruptcy if in fact you try to enforce it. The second part of the question that Ben put up here is, he said it, on one hand, it's positive leverage toward the customer's expansion and growth. On the other, in a bankruptcy, you have secured creditors ahead of you. That's why it's very important, if you are thinking of taking a security interest, to run that UCC search before you do. Because if you're going to take a general security interest in furniture, fixtures, equipment, stock and trade, inventory, et cetera, you're going to be in line in accordance with the priority set by chronology. Who filed first gets those assets. The only time that what you can do is become a purchase money secured creditor is to protect only those assets which you which you sell or supply the funds to purchase. And then you have other rules. Now you have to notify every prior secured creditor who has a security interest in the same goods that you are going to look to. And that notification has to be very strict. You've got to send it by either certified or registered mail so you know they got it. Maybe follow up with an email. Snail mail, never. Don't waste your breath on snail mail. It'll take 2 weeks to get there and they'll claim they never got it. So something to ensure that they got it. Once they have gotten it, they may come back and squawk, and that's a possibility. But if they don't squawk and you then file your UCC financing statement, you become number one over that creditor to the extent only of your own goods or those goods that you supplied the funds to purchase. And the last part of Ben's question is, other than that, what risk factors apply pre-liquidation? And I think I really just answered that. If you're a general secured creditor, you will be in the order or priority set by a chronology. If you have a purchase money security interest, you may be number one.
And the only thing I would add to the purchase money security interest issue, if that inventory once delivered gets commingled with all the other inventory, then you're going to have a hard time showing what your lien is on. So if they're separate, if you can segregate it by bins or maybe by serial number or something of that nature, that's important to make sure that you know what was being purchased, and that you have, acquired that. It gets complicated when you get a purchase money security interest, but Wanda's exactly right. That's how you can get priority, even though there's an existing lien on the assets, and that's important. Finally, the comment on chat mentions that they provide a listing of equipment, including but not limited to, and then they list it. That is a good idea of accomplishing it. I agree with that point, because that's a way in which you get a general lien on all the assets that you're trying to attach, and then you can specify which ones you're talking about as well. And that's a way to get it both worlds. Oh, one other thing. It is important sometimes when they go into bankruptcy, as to, particularly when you have a lien on accounts, the problem is, what are your proceeds? What are your accounts that relate to your assets? And you may have a lien on inventory and other things, but once all of those, if there are other liens that exist, once they're all commingled, then you lose your lien as your ability to trace to the funds of your assets. And there are ways in which you can accomplish that. You can get a deposit account that's designated for you, where the money goes into that account, and it's segregated from the other liens and other assets that may exist, and that would be something important, because what happens is when they do go into bankruptcy and you are able to assert a lien on these accounts, there are further limitations as to what they can do. It's what we call cash collateral, and that can limit what the debtor can do with those funds. They can still use it perhaps, but they have to they either have to get your consent or go to court and get it approved, at which point you should receive some protection of your interest that's being used. So having the ability to trace it through into account can be quite valuable for you.
Well, and let's take that and move to bankruptcies. And the next question, what steps can we take to limit our preference exposure? So
You want me to start with that?
you might as well keep going.
Okay. All right. Well, first of all, for a preference, if it's then the most trade debt things, these are payments made within 90 days of the filing of the bankruptcy. There needs to be an antecedent debt and the payment made to the creditor that within that 90-day period, which are generally pretty easy for them to establish. Then the burden shifts for you to prove certain defenses that you might be able to assert. And there are a couple of things that I think that you can do to make this more beneficial. First of all, when does the preference period start? Well, it starts when there's been a transfer of funds. The transfer of funds occurs when the money that you've been paid is actually clears. So if you've received it and you sit on it for a week, you've given them a whole nother week of a preference period, but essentially. So, you know, if you receive checks, by all means, deposit them right away. Get them in. Obviously, the best thing is to get electronic transfers. Then that's immediate at that point. But transfers by checks are going to clear, and that's when the transfer takes place, when the money actually cleared, not when it's deposited or when it's received at your office. So don't just sit on payments. Go ahead and put them in, because you just never know when they may file, and that 1 or 2 days may make a big difference. Another thing that comes up is there's a new rule that allows you a priority claim if you get what we call a 503B9. That's a code section, and it's when you deliver goods within 20 days. And if you've delivered goods within 20 days of them filing bankruptcy, your whatever amounts is owed for the payment of those goods is a priority claim in the bankruptcy. And there's also, and we'll talk a minute about what we call a new value. Those two kind of work a little bit almost against each other in a way. But in any case, it is important, I think, just to try to stay within 20 days. You know, in other words, if you're delivering something and if they haven't paid you within 20 days, I wouldn't ship again until it's been paid, because now that payment is going to be at risk, a preference risk later on down the road if they were to file within 90 days. But if you've got paid within 20 days, then you're okay. Well, at least you got a priority, and you still might not get distribution back if the case has no assets. But if and hopefully you should get some distribution. And then the other thing is to think about a couple of the defenses that exist. One is that payments received in the ordinary course of business are not a preference, even though you've received it within 90 days. If it's a utility that was paid timely or your debt was paid timely, you would assert that that was paid in the ordinary course of business. There is no intent in the preference law, so they kind of manufacture the intent as to whether it was late. And if it was late, then they kind of construe that to be more in the preference area. If it was on time, then it wasn't intended to try to prefer you over somebody else. Now, so what happens? A trustee files, a debtor files bankruptcy, that's liquidated, a trustee is appointed. Now a trustee has all the books and records, and the trustee starts, all the employees are gone. So the trustee starts looking through who's the books and records, and they find, well, okay, you sent all these dunning letters and or emails saying, if you don't pay us, we're going to cut you off, or we're terminating we're not shipping. And so all of that kind of adds to the trustee's statement, well, this sounded like it wasn't in the ordinary course of business. You were threatening, certain actions. And so you might, well, I mean, communication maybe by phone, if that's available and you've got a link with somebody, might be better than sending emails out, because more than likely the person that received it by phone is gone. So there's no communication as to what, or evidence that that was what was going on in those communications. The final thing to protect yourself is what we call the new value exception. And that is that when you receive a payment, and the incentive by the preference law is to allow you encourage you to continue doing business with someone. And so what they provided in the preference law is that once you receive a payment, if you make a shipment after the receipt of the payment, then you get to offset that shipment, the value of those goods that were delivered, against any preference claim. So if you got paid $10,000 and then 2 days later after that, you ship $10,000 worth of goods, there is no preference if that 10,000 was received within 90 days, because you shipped new value within that period right afterwards. The key to it is that it has to be after the delivery of the payment. And so you can't just, and a lot of times they'll say, here, I'm going to fax you or scan to you a copy of, the shipping label. We're sending it right now. Please ship us the goods and we'll send the payment right away. Well, that doesn't work. It has to be after you've received it. And it isn't, they do allow, in this case, you to just credit the receipt, not when it gets cleared. That's kind of different. The law is a little bit different here. One is dealing with the exception or defense. The other is dealing with the preference itself when the transfer occurs. So you can rely on the fact that you received it, and then you can ship, but you need to have a record of when you received it. And so that's why I recommend put it in the deposit, show a record that you deposited the money on this date, then you can ship on or after that, and you'll have availability of this new value defense in that respect. So those are just certain things that you can do that ought to be a part of your policies in dealing with particularly someone who you consider to be having trouble.
So if I might add a couple of things, and of course, I agree with everything Bill has said. I want to clarify, though, just to make sure that you each understand that when Bill was talking about the 503B9, goods shipped within 20 days, remember he's talking about goods shipped within 20 days before the filing of the bankruptcy. If you're already in bankruptcy and you're shipping goods, they are an absolute priority because that is post-petition debt that they are incurring. So I just wanted to make sure everybody understood that was pre-petition. I also want to chuckle a little bit because Bill used the word ordinary course of business are payments that are timely. And of course, Bill and I have probably litigated over the years, not necessarily against each other, we haven't, but with the trustees as to what is timely. Many of you or most of you might have invoices to say 2% net 30. So obviously, anything received net 30 is ordinary course of business. But how many of you have invoices to say 2% net 30 and your clients, your customers are actually paying you in 45 or 50 days? Your 45 or 50 days becomes ordinary. And the way you will defend against a preference is by creating a spreadsheet. And I recommend the spreadsheet should go back 2 years and 90 days, because you want to show 2-year period of time before the preference period, which starts at the 90 days. And if in fact you show that despite your invoices saying 2% net 30, really ordinary for you has been payments of 47.5 days, then that's what is ordinary. And if you can show that all the payments received during the preference period were at or about, and I would say, I usually like to use a 10-day spread. So at or about 37 to 57 days, that is probably going to be deemed ordinary. You'll hear a lot of people today, using theorems on the spreadsheet as to whether it's a weighted average or another type of average, but generally, to be as simplistic as possible, if 45 days is your ordinary and you get payments between 35 and 55 during the preference period, that's probably going to fly. What about you receive a check from your customer and it bounces, and during the preference period they replace that bounced check with a good check that clears? That is never going to be an ordinary course of business. There are some courts that will just merely say the fact that the check bounced and was replaced tells us it was out of the ordinary course of business. And there are cases coming out of the 11th Circuit as long ago called B Furniture, and there are cases coming out of the 9th Circuit that basically say if a bounced check is replaced during the preference period, that is not going to be ordinary. Then Bill did clarify that there are two different kinds of receipts within the preference statute, and I'm going to address the receipt in terms of when do you ship new goods for the new value defense. Today, I see a lot of delinquent customers, and you are withholding credit. You're on credit hold. You're not getting another piece of equipment from us or inventory from us until you make payment on your past due debt. And then I'll ship you. I'll release the order. And they send you a wire confirmation. Don't release the order yet, because I watch for wires that might come into my office, and we may get a wire confirmation dated May 24th, but it doesn't hit my bank account until May 25th. So what I have always cautioned my clients to do is, great, you got the wire confirmation. Now you know it's on the way. Don't release those goods until your bank tells you the money is in your account, your company's account. Then and only then release those goods. I had one client who had a situation with a wire, waited and waited and waited and waited. The wire finally hit their bank account. Then they released the goods, and the trustee came back and said, well, it was all on the same day. How do we know you really released goods after you got the wire? And my client was able to show, because the wire transmittal from my bank was 11:08 a.m. and our goods left our dock at 12 noon. So that it actually comes down to that kind of minutes sometimes that the new value goes out the door after the money has come into your hands. Now, there is a question up here. In 2008, Linens and Things was a major customer to former employer, a wholesaler of area rugs. As it became apparent that Linens and Things was having cash flow issues, we exercised due diligence, trading extra payments on accounts for new shipments. For example, you want $5,000 in goods? Give us $7,000 and we'll apply the $2,000 to the old debt. This is very common. I see my clients doing it all the time. Eventually, this company says that it moved to prepaid sales. So at the time that Linens and Things filed bankruptcy, it had little or no loss. However, the trustee came back to them requiring the previous 6 months' sales be included in the bankruptcy, effectively punishing them for our cautious diligence. I am not sure how a trustee, without knowing more from you, how a trustee could go back 6 months. However, the rule is, as Bill already stated, that a preference is any payment you received within the 90 days prior to the filing of the bankruptcy and payment of an old antecedent debt at a time when the debtor is insolvent, that gives you more than every other creditor got. However, if you are deemed to be an insider, then the trustee can go back for 1 year. So while not knowing more from you other than what you typed in your question and answer box, I'm going to suggest that it could be you were engaged in such close communication with this debtor that in fact, the trustee said you became as though you were an insider because you were controlling what the debtor did. And I had that in a bankruptcy case where we actually went after one creditor because what they were doing was they said, hey, we know who you're going to pay and we know who's important to you and we're important to you. So you're going to pay us. And okay, so you can pick, and I'm just going to pick some names off here. So you can pay Sohini and you can pay Biman, but don't worry about Sansa and Michelle. They'll continue selling to you anyway. And by actually telling the debtor what to do, this creditor was deemed to be an insider. And I represented the creditors committee in that case, and the committee had authority to do the suing on preferences, which committees don't automatically have, but we had that authority to do so. And we went after that particular creditor, claiming them to be an insider, that they had manipulated the debtor, told the debtor what to do, and therefore became an insider. And the bankruptcy court ruled with us. They appealed. The Second Circuit ruled with us. Well, the reason they kept appealing and why they were so upset was because we also claimed it was RICO, because other committee members informed us that they did this all the time. And what RICO stands for is Racketeering Influence Corrupt Organizations. And we said, you are a bad player. You do this to every debtor and you force them to pay you and ignore other creditors. And finally, after the Second Circuit ruled again in our favor, and they were going to have to seek permission of the Supreme Court to be heard, they came back and said, look, we'll just pay you if you just drop the RICO. And of course, all we wanted was the money in the estate. So we got the payment. So in your case, again, I don't have more details from you, but be careful with how closely you get involved with the debtor, because it could put you in the position of being deemed an insider. And that's the only way they would have been able to go back 6 months as opposed to the 90 days. Bill, do you want to add anything?
Yeah, the only thing I would say is that I agree with you, as to what it takes to be and how best to show ordinary course, because the statute says that it was in the ordinary course or financial affairs of the debtor and the transferee, in other words, the party receiving the money, or according to ordinary business terms. So you got both ways. And so if it's outside the ordinary business terms, then that's when you establish what was the relationship between the parties and what was in the ordinary course of business. And courts, if it's 10 days or, late, but they're always 10 days late, then they will conclude that was kind of in the ordinary course of business with those affairs.
Good point, Bill. And one point to follow up on that point, most creditors today belong to trade creditor groups. And you can actually obtain it through your trade credit group. You can obtain it through companies like NACM, CRF, Dun & Bradstreet, perhaps. What is in fact going on in the industry? Because if you are getting paid and it seems completely disparate from what you normally get paid, look to see if the industry standard will be your ability. And if you find out, in fact, 56 days has become the industry standard, instead of using the subjective ordinary course of business, you can use the objective ordinary course of business. We recently settled one. We actually hired the accounting firm BDO to come up with an expert report as to what was the industry standard ordinary course of business. The trustee came up with its expert report as to what the industry standard was in that case. And now we looked at battle of the experts going into a trial, and gee, guess what? We settled.
Okay, the person who asked that question indicated that they were a minor vendor. So, based on what the two of you have said, it would seem then that there's something in terms of how they communicated those deals must have been the problem.
Yep.
Okay, let's move on, and my apologies for clicking back and forth between screens. Here, so we want to take a look at reclamation claims, and with the evolution of the administrative claim 503B9 portion of the bankruptcy code, are reclamation claims still ever used? And if so, in what scenario?
Well, in the interest of time, let me just address that very quickly. What 503B9 gives you is the right to get a priority payment. It doesn't give you the right to recover the goods that were delivered. Reclamation allows you a period of time to go back and make demand for goods that were sold and delivered and then recover. The problem with reclamation under the UCC is that it is, if they have a lien, where they granted a lien on all their inventory or equipment or whatever it was that you sold them, that lien is going to have priority over your reclamation. So I think the answer is yes. 503B9 are much more reliable because they are kind of automatic priority claim, whereas reclamation is very limited in what you can recover.
Okay, and let's move on then. So for talk about rights on collect shipments, and this is an interesting case that came up. So for vendors shipping collect or COD, what are the respective legal positions of the customer, the carrier, and vendor when a customer claims non-receipt of goods and refuses to pay the vendor's invoice? I'm going to give that to you, Wanda.
Sure. And this is a very actually simple question, because most of the carriers will use sealed cargo containers, sealed trucks or sealed cargo containers. And if that cargo container or that truck arrives with a seal on it and the customer claims non-receipt of goods, that customer has no leg to stand on. If the seal is broken, then the customer has a big claim. But otherwise, if that claim is intact, there is absolutely nothing that the customer can win in claiming that they did not get the goods. And that was a very quick answer because I see we're almost at the top of the hour.
Right, and let's move on to another. No, that's not the right
No.
one.
Right, we answered security interests.
There we go.
Okay.
Electronic funds transfer. Why is EFT fraud becoming such a big problem? And what are some of the different types of payment frauds? And are you seeing any new variations in terms of AR fraud?
Boy, wire transfer fraud is becoming a very, very popular topic these days. It kind of goes along with cybercrime, and that's really what wire fraud is. And what is being recommended today is that get your instructions on the telephone. People, hacksters are intercepting wire transfer information, emails, and sending out fraudulent emails so that the creditor who is supposed to get the money never gets the money. The debtor who sent the money says, but I have proof, I sent it to you, and here were your wire transfer instructions. And now we, of course, have a situation of, is the debtor going to pay twice? Is the creditor going to go to its insurance carrier? So it's a real problem today. And the banks themselves are suggesting that you pick up the phone and confirm wire transfer instructions before you send them. I was on a similar panel last week ago at the Commercial Law League conference, and one of my colleagues said that whenever they either initiate or accept a wire transfer, there is a link given by the bank, and they have to go in with a unique password every time they do an electronic transaction. So that's another way that it can perhaps take place. Bill, is there anything else you're seeing in terms of AR fraud?
No, I think you addressed it. It's the emails and trafficking that does interfere with, what you thought was a legitimate transfer.
Okay.
Okay, and here's our last question. What's the best way to minimize attorney fees, especially if your business is spread across different states and jurisdictions?
Bill?
I'm going to toss that out to
Okay,
toss that out to either of you.
I'll add my 2 cents first. First of all, I think it is helpful, particularly if you have a series of routine type matters, like filing proof of claims in bankruptcy or doing something, that you discuss that with your firm and get them to commit to a fixed rate for those types of things. They'll do it if you're doing enough volume with them. And that's what you want to try to accomplish, or a fixed hourly rate or something of that nature. In other words, they won't be at some senior partner rate. And so that would be one thing that you would want to do. Secondly, as to litigation that might be pending, and of course they can get out of hand. One thing that I found very effective in kind of the sooner you can bring it to an end, the cheaper it's going to be. Of course, that applies to bankruptcy cases as well. But a mediator might be something you want to think about, and getting the parties to sit down, talk about it, work it out. A lot of these mediators are very effective, and you'll be, I would say the average is probably greater than 70–80% that they get settled once you get into a mediation. So that would be another way to try to minimize the attorney's fees that you're involved with.
I would like to add one other thing, your documentation. If your papers are a mess, your attorney is going to end up spending more time trying to figure them out. In particular, we talked about preferences. When we say we need 2 years of data, we really do need 2 years of data. And if you can generate that spreadsheet for your attorney to use in creating the preference analysis, you really don't want to spend money on having your attorney go through. I've had clients who have sent us thousands of invoices because they say, we have no idea how to create a spreadsheet. Well, that means they're paying either a paralegal's fee or a lower associate's fee to do what you credit managers can do very well. So your paper and your security agreements, make sure they're clean, make sure your invoices, your purchase orders, your proofs of delivery, all of your documentation, the cleaner it is, that is another way you're going to minimize attorney's fees.
Okay, thank you. And just for those of you that are on, we have gone over the hour just by a little bit, but we have one more question, and we're going to try to go through this quickly. If you can't stay with us, this is being recorded and will be available. And as we mentioned, you'll be getting a copy of this. So what we're going to do here is this sort of the lightning round with these questions. So on each one of these, I'm going to ask one of you, what are the 2 most important things that credit managers should know about? And I'll give the other person a chance to add in anything else quickly. And so let's get going. So what are the 2 most important things a credit manager should know about in terms of filing bankruptcy claims? Bill, I'm going to start it off.
I'll shoot with that. First of all, be timely. Know when the deadline of filing the claims. Make sure that you don't get behind that. And attach you need to show how your interest is calculated through the date of the filing and attach the documents. Otherwise, what's going to happen is they're going to object to it and you're going to end up having to spend more time in defending it. But if you got a security interest, if you got promissory notes, if you got credit agreements, other things that relate to the claim, attach those documents.
Anything to add, Wanda?
Not to that, I'll take another point. I see two things here, but I'll take one at a time. Granting credit to the new customer. Too many times I see credit applications or credit agreements, as Bill refers to them, and they are insufficient, incomplete. They may have the name of the company just by the trade name. So you end up litigating, sending it to a law firm, and then we have to spend time trying to figure out who your customer really was. I had one case where the name of the customer was Bill Ray. And when I did a Secretary of State search because the customer only had Bill Ray, that's it, Bill Ray. There were 16 Bill Ray companies organized in the state of New York. And we had to go into every one of them and figure out which one was truly the corporate debtor that owed the money to our client. So when you're granting credit to a new customer, make sure you get all the data, the information, who they are, where they are, what they are, when they were established, where they're doing business, etc. And cell phone numbers. Get cell phone numbers from the officers that you're going to deal with and get permission to always use those cell phone numbers to contact them. So what's your second choice, Bill?
Well, I would go, if the preference claims what we mentioned, but I would highlight the two important things: stay within the 20 days and don't ship until after the payment.
Okay. Any two quick recommendations on suing a debtor? Wanda, what, you're putting a claim together for an attorney. What do you want to see from your client?
Well, okay, that wouldn't have been my second choice, but I'll take it. Documentation. I want to see the credit application. I want, if there's a security interest, I want to see the signed security interest, the UCC filings. I want to see invoices, packing lists, proofs of delivery, all of that data, any email communication as to promises to pay, or especially any email communication as to problems or disputes that the debtor may have with your material. I was in the middle of a lawsuit. We had been going on discovery, going on a year, when finally we found out that when the debtor was claiming the steel was cut wrong, the debtor was right. The steel was cut wrong. Our client was wrong. And ultimately, of course, they settled. So making sure documentation and facts are all in order. The second one I'm going to steal this for a moment. The second one I want to say that's so critical are consignment agreements. Maybe a lot of you don't do consignments, but when you do, make sure you do them properly. Too many companies get burned when there's a bankruptcy. In the Sports Warehouse case, almost every vendor got burned who had a consignment agreement, because either they had no agreement and they filed a UCC, or they had an agreement, but they never filed the UCC, or they never did the notification. So consignment agreements, if you're doing them, make sure you have talked to an attorney and you're doing them right. And Bill, you get the last word. You get to choose one more.
Well, I'd go by the documents down below on personal guarantees. And in that one, you want to be sure you've got the right name of the entity and the officer that's signing on that guarantee. It's just so many times I see a signature and it's not by an officer or something, and it's just not effective to give the obligation that you want on that guarantee. And if and as to the second thing, I would say be broad in the debt. The debt may change, the obligations may change. You can say this debt and any other obligation owed to this, by the party. So be broad in your descriptions there of what is owed. Promissory notes kind of similar. You want to, the thing that you can maybe make an error on is having too high an interest rate. You got to worry about usury in declaring what is the amount, because you're thinking you're fixing the amount of the debt in the amount of the note. So it's not just some variable note amount. It's going to be that amount that's in that promissory note. And then it's got a various interest rate that is to be applied to it. So that needs to be carefully adhered to when you're structuring that.
We actually only have two more things left on this. Any of you, small business privacy laws, anything credit managers should know?
The credit managers should know that new privacy laws are being established every day. California, of course, is the first state that became very onerous with its small business privacy laws. And even though you see some of these privacy laws and they seem to be geared toward individuals as opposed to businesses themselves, you have to be careful, because many times on your credit apps, you may have a small business, but then you may ask for information about the officers. You may even get sometimes social security numbers of the officers. So when these new states in California, Colorado, Virginia, I think Pennsylvania are among the states that are really jumping on board with new privacy laws, and any personal information is protected. So credit managers need to read your industry magazines, look to attorneys like Bill or myself and others, and make sure you are up to date with what the privacy laws are.
And then there, I see in the chat, there's a question about e-signatures versus wet signatures. I think most laws now are permitting electronic, and so they can be, but you just need to verify and confirm that in the jurisdiction that you're in, that's an effective obligation.
Okay, and lastly, we have issue of state laws and bad checks, and we know things vary from jurisdiction to jurisdiction. So what should credit managers do when it's a bad check from a customer outside of their own state?
The NACM publishes a book called the Manual of Business Credit, or I forget the title, Manual of Business Credit, I believe it is. And they contain a listing of all the bad check laws as an appendix to that book, number one. Also, there are companies called Lawless, American Lawyers Quarterly, and the General Bar. They also contain on their websites up-to-date bad check laws. So those are just some references I can give you as to where you can find them.
And the only other point I'd add there is that that's another thing that you might want to add to your the credit agreement, and that is that a charge that if there is a bad check, that you'll get some amount, because it's going to take some money to ultimately go through that process.
Right.
Very good. Well, we appreciate the information that has been shared today. What we want to do is, we've gone through the questions. I think it looks like they've all been answered. And so we please ask that you would rate this Hayako session. You should have seen the link for doing that in the chat. And then we want to thank you for your attendance and your participation in this. If you have additional questions, you can email us at mikeyakemchuk@hayako.com. That's MIKE.YAKIEMCHUK@Hayako, HIGHAKO.com, and we'll get back to you. And as we mentioned before, the material for the sessions as well as the recordings will be live on hayako.com very soon. And thank you everyone for participating in this webinar today. And thank you, Wanda and Bill, for this great session. I hope everybody found it useful. And that's it for today. This is Dave Schmidt signing off for Credit Today. Bye now.
Thank you. Bye.
Thank you. Good day for everyone.